He has a contact gunshot wound to the head, and he is deceased.
Tom killed himself, and he literally, in that moment, he gave me the bird. And then the state of Florida decided that I must have killed Tom, and they have been giving me the bird ever since.
Okay. This fourth episode of Giving Me the Bird, I'm here with my forensic consultant expert, David Zeliff from Second Look Training and Consulting, who has taught me more than I ever needed to know about crime scene investigation and forensic analysis. And today we're talking about the Fourth Amendment. So, Dave, let's talk. In this case, there are a lot of Fourth Amendment issues, and I think the most at the most basic level, just to break it down, the Fourth Amendment is what protects you from unreasonable search and seizure.
Yes.
All right. And you used to train people about, specifically in law enforcement,
Yes.
about what that meant for law enforcement officers when they arrive at a place where there's a possible crime that's taken place and what they need to do in order to make sure that anything that they see and locate that day is actually something that can be used in court. So tell me.
The biggest way to get your entire case tossed is not to do the right things in the very beginning when it comes to the Fourth Amendment. And the Fourth Amendment covers the residents. There's special protections for the residents, but that extends even deeper when we're talking about digital media today because of how much data is there. But it also relates to the individual's person. Like, I can't come up on the street to an individual and say, I think you just called a drug dealer. Let me see your phone. And so I take your phone. I'm in uniform. I'm wearing a weapon, and you comply because I'm a police officer. So I take your phone and I say, damn, I can't open this phone. Open your phone for me.
And I do it because you're wearing a weapon and you're a police officer.
Once I'm in, I look at what I want to look at, and then I say, I'm taking your phone, my friend.
I've heard this before.
And so this is kind of what happened in this case.
Yeah.
And it's completely improper. I can't just fish, right? Like, if I'm going to go fishing, I have to have a specific license for that type of fish.
Right.
I guess that's how I'd equate it. I can't just go into this phone and start fishing around for everything and see if there's anything in there at all that would help me prove a crime against you.
This is how a warrant works. I mean, and what people may not be aware is that a warrant is an opportunity for a judge to review. It's a check on the power of the police. So you go to the judicial branch and you say, hey, we want to search this phone or this residence or this warehouse. We want to search this car, whatever it is. And you have to explain your probable cause in order to conduct that search. So in this case, the police proceeded without a warrant.
So you've got a death scene, and the responding officer, their responsibilities are pretty simple. They should initially check for signs of life. That's number one, right? Human life is the most important issue.
Right.
So if the individual is deceased, then they've got to clear the scene. In other words, they want to render it safe. So they have to walk through and ensure that there's nobody else hiding in a closet with a gun or anything like that. If there's individuals in the scene, then you want to clear them out. So then you secure the scene. And then you've got time, and the time is going to be required because, as in this case, you've got a gunshot wound, and it's an equivocal death. It's in an equivocal death. You don't really know what the manner of death is. You can't prove the manner of death. Generally, you're not going to be able to say that it's a suicide unless it was witnessed by someone.
We got to back up because people might not know what the manners of death are. So as I have now learned from my friends at Second Look, there are 5 manners of death that we talk about. There's tons of ways that someone might die, but they all fall into these 5 categories. The first is natural causes. That's pretty self-explanatory, heart attack or old age. Or second, there's an accident. A person falls off a ladder, or they drown. The third, someone is killed by another person, homicide. The fourth is suicide. The person kills themselves. And the fifth is kind of the catch-all when it's unclear, despite the investigation that's done, which of these is correct. So that's I'm not sure. There's some evidence of this, some evidence of that.
Right. That's undetermined.
Right. And so that's the undetermined.
So cause of death is always the mechanism, right? So cause of death is like gunshot wound, stab wound, a heart attack. In this case, it was a gunshot wound to the head was the cause of death. And the manner of death was equivocal. So you can't make a determination. We can eliminate accidental because it's a hard contact gunshot wound. Generally speaking, in an accidental gunshot wound, it's going to be where someone was cleaning a weapon and accidentally shot themselves.
And when you say hard contact wound, you're talking about the muzzle of the weapon is pressed
Yes.
against the decedent's head in this case.
Yes. And then the second one you can rule out. So you've got accidental, you can rule out natural. Undetermined, we're not going to pay attention to. So that leaves us with homicide and suicide. And those two manners of death have to be investigated very thoroughly, both. So you've got two parallel tracks of your investigation. You have to investigate both of them very thoroughly in order to prove one and disprove the other. And so when you have an equivocal death, though, you have to immediately clear the scene, get everybody out, secure the scene, and stand post. Then you call and you ask for the detectives, the CSI, and all the other people to come. And then what you have to establish is a perimeter. So establishing in an apartment's pretty easy.
It's a lot easier than like out on the street.
Yes. If you're outside in a parking lot, that's much more difficult. But, traditionally what we operate with is a double perimeter. The inner perimeter is about a stone's throw rule from the body. Beyond that inner perimeter, you want to set up an outer perimeter because what happens is in a lot of cases, officers are going to come, they're going to want to help, but you don't want them in your scene because when too many people get in the scene, things are done, people are touching things, people are moving things. And then me as the CSI, I'm thinking, wow, this was in this position when in fact it's been moved 3 times.
Right. I remember thinking it's like a circus here. And I believe there were a total of 12 police officers, everyone, the highest ranking being a sergeant. And you've got a couple detectives and a field training officer. And then you have a bunch of patrol officers. And so there was a lot of activity there. And when we've gone through the body worn camera footage, you can see a lot of evidence being moved. I mean, there's people stepping on things that they should not be stepping on. I mean, perilously close to my uncle. That cannot be best practice.
Then the responding officer, his responsibility really, or her responsibility is to secure the scene and ensure that nobody goes into the scene. That officer will establish a crime scene log. And this is just standard national practices. But that crime scene log is maintained to say when an officer, you mark them down, what time they get there, and when they leave, you mark that down. This is available post-scene. Supervisors might show up at the scene and they want to see what's going on. They want to go in and see what's going on. What we would do is take a quick video of that and we would have it outside where they never had to enter the scene so that they did not contaminate the scene. One of the things that will prevent that is to let them know that everybody that's on this crime scene log is going to have to give up samples. They're going to have to give up DNA. They're going to have to give up fingerprints. They're going to have to give up hairs because all of those things can be used as elimination. Hair, not so much anymore. It's more DNA and fingerprints.
But I think you're talking about where there's a case of a suspected homicide and you don't have a considered or a likely suspect.
But in this case,
in this case,
it wouldn't matter. They did not have a likely suspect. They believed they had a likely suspect, but honestly, you can't make that assumption up front, right?
Well,
because you could have been asleep.
I wish they hadn't.
You could have been asleep.
I was asleep.
And so what happened? You wake up to a loud noise. So in the end, the bottom line is we don't really know until all the facts are in, and you don't jump to assumptions. In a scene, you can't jump to conclusions or assumptions. And so in this case,
and part of what would have slowed down their process may have been applying for a warrant. So because when you apply for a warrant, you have to meet certain criteria. You have to display to the judge what your probable cause is to ask for those things.
Right.
So
there's plenty of things to articulate the affidavit, and that's the reason that you slow it down. You get everybody out. The next thing is for the detectives to take what's been given to them to that point and then go in and get a search warrant for the house. Okay. But it has to be specifically for those things that are related to both manners of death. I'm not doing it for just items that are related to homicide.
Well, this is because what you're supposed to do in an equivocal death situation is you're supposed to review for both possible theories.
Correct.
It's like you have 2 job candidates and you want to hire the best person for the job. So you have to vet each of them. you're not going to be able to make a decision between the two of them if you only talk to one of them, if you only look at the one's work. The other candidate is not really a candidate then. And that's how I feel this was handled. But you don't always need a warrant. So, and these are things that have been, we're talking about the scene here, because to me, that is where this all kind of started.
So the way I've always taught this is, if you've got, in this case, you've got the niece and the uncle and the niece.
The parent.
We're staying in the same residence, and he has a contact gunshot wound to the head, and he is deceased. And so you become the other person in the residence that would automatically become a suspect, right?
I now know.
And so in that case, the only other way that you could legally search that scene, some people would say exigent circumstances. As soon as you've gone in and checked for signs of life and sealed the scene up,
right,
and secured it, that exigency is gone.
And that's, I mean, from a legal perspective, the lawyer in me says, all right, now I've looked through that, and absolutely, there is no question there. Exigencies, whether you're looking nationally or specifically in the state of Florida, it's a short-lived thing. You have to remember, the police in this case were on scene for roughly 5 hours. The exigency was finished within minutes of the first officer's arrival.
I could legally ask Shannon for consent.
Actually, I don't know that they could at this point, because the perspective so we've been told many things over the last few months about why it is that the police did not, in their opinion, need a search warrant for the residents. And some are more interesting than others, but some of them mean that if you believe that Shannon Gallagher had no standing because she was only there for about a week, there to give care, then she wouldn't be a person from whom you could really ask for consent, because she's not someone who so it kind of cuts both ways, I think, there for the consent.
Okay, on the standing, that's a good point. Standing is a good point, but she had been there long enough to have established standing.
And honestly, that's not a very long amount of time. There are cases where someone has a suitcase with them because they're planning to spend the night, but they have not yet spent the night. They have standing.
The one thing that I always recommend, though, is don't go to the other person that's in the residence, because oftentimes that person is your suspect, right? And so you don't want to get consent from that person.
They can retract the consent. They can say they never gave. I mean, it's interesting because these are the type of things that we're supposed to be able to rely on body-worn camera footage, and there should be a written consent, I would think, if you're going to seek it. But I hear what you're saying. Yeah. It would be really a risky thing to ask consent of your would-be suspect.
Yes.
But so the other reasons that we were told that the police in this case didn't think they needed a search warrant, they kind of run the gamut. We were told beyond exigent circumstances, well, you invited us in. Then we also have that you had no standing because you had a regular home elsewhere. You were only a temporary resident here. You had stayed for, I think that person claimed, just a couple nights.
Yeah. And that's one of the more experienced officers. The more junior officer said you invited us in, and there was exigent circumstances.
Right. And the exigent circumstances, when you look at it, when that was pressed in this case, okay, what do you mean by exigent circumstances? The response back was, well, there was a dead person and a gun. Okay, well, that doesn't meet that test either. Yeah. Oh, and then the no standing, and then there's also, we had reasonable suspicion.
That's pretty interesting, because really reasonable suspicion, that's more of an indicator that you need a warrant.
Right, that's how
But it's really simple. When young people go out to process a scene, it's important to secure it and get a warrant. And the parameters of the warrant are important. It prevents just going through everything. You can only search for those things that are within the scope of your warrant.
Right.
So if I don't say I'm searching for a needle and I want to look into a matchbox for a computer, I can't do it.
Right.
Now, if I put down needle, maybe I can look in the matchbox.
Yeah, but that's the famous elephant in the bread box. To me, one of the problems with the search warrants, and there were 3 search warrants obtained in this case that we're aware of. To me, the interesting thing that I didn't, as an attorney, I had no idea that such broad access would be granted by a court. And you have here 2 Google accounts I owned. Of the 13 categories of items from those 2 Google accounts, a couple of them are limited to 6.5 months. But what people need to appreciate out in our viewership is that when if a warrant is granted over your online account, your TikTok or your Instagram or your Google, your Dropbox, that's a massive amount of data. If they don't limit it to time. So for me, it was the breadth of this, and it was especially the temporal breadth. Just I cannot imagine how, if you think about, in this case, the Google warrants were for everything from December 1st, 2021 through June 15th, 2022, 6.5 months. And that's 3 months almost where my alleged co-conspirator, Tom, had already passed away. So what are you looking through my Google accounts for at that point?
The offense on the affidavit was assisted self-murder.
Right.
So your co-conspirator could only be one person.
That's how I would read it. But the basis for the warrant application, I feel, was really
too broad.
It was too broad. I don't think that the judge reviewed that appropriately. When you're looking at, even for my cell phone, you're asking for a month's worth of my GPS data. Everywhere that phone has been over the course of a month, from February 2022 through March 21st, 2022. Well, in another case in the same courthouse, the same judge who had signed off on one of 2 of the 3 warrants here said, in connection with Jamel Demons' case, the YNW Melly case, that many of the things that had been sought in 13 warrants in that case were too broad. And if you look at that case, there was a 6-hour window where they were allowed to get his phone's GPS data.
And traditionally for me, that's what I've seen. For me, these affidavits don't have meat. There's nothing in the affidavit that really articulates what my probable cause is for wanting all of your messages for a 6-month window.
Especially if my co-conspirator is already passed away.
Right.
What am I chatting with?
And the other thing is, you sent an email to the officers that explained that I'm an attorney.
Right, I did.
And I have clients, and I need to preserve my attorney-client privilege. And they didn't establish a taint team. You want to explain a taint team?
So a taint team could be set up such that when the results from an electronic or digital dump come in, you could have one team who would go through that full universe of data and then take those things that are actually relevant to this case and provide those to the detectives and the personnel working this particular case. The goal of the taint team is to keep the unnecessary and unrelated data, especially where there's, client privilege involved, from eyes that don't need to have eyes on. So that could have been done, but it seems here that that's a completely foreign concept.
Now, I think the interesting testimony for me was that even in those cases where date parameters were set, the entire phone was captured.
Yes.
And when in the testimony, the individual examiner indicated that he has rarely been given cases where there were date parameters or time parameters placed on the data.
And I remember, you might remember I said, well, or even with the case of like GPS data.
Yes, because for me, traditionally in my career, it's always been very specific.
Right, it should be.
And the data that we're looking for, we can't just fish. Again, we can't just open it up and say, I want to see everything in the book.
So there is this distinction between the residence, albeit this was my uncle's apartment, not mine, but I had been staying there, especially as he needed more help. They have the messages from Tom saying, I need your help. I need you here. You should be awfully clear that I was there and that I was residing there for care. And there's also a lot of evidence there. I have a bed in the living room. I'm in my pajamas and robe while the police are there. I have prescription medication in the bathroom drawer. My dirty laundry is on the bathroom floor.
Your laptop sitting in the living room table.
Right. And a lot of other personal property there. So I think that should have been really clear, and that this search should not have been done without a warrant. So let's see. I wanted to talk a little bit about the other Fourth Amendment ones.
Yeah. I was just going to say, the other, when we're talking about your person.
Yes.
Almost immediately, the detective contacted the CSI. When the CSI arrived, that individual basically processed Shannon. What I'm looking at is just rolling your sleeves up and And what I'd relate that to is like a stop and frisk, right? If I'm out on the street and I stop you and I want to talk to you, that's fine. I can stop you. I can talk to you. I can even ask you to empty your pockets if I want to.
Interesting.
But the thing is, what I can't do, if I want to do a pat down, if I want to pat you down, there's a lot of controversy about the pat down, right?
Okay.
So what I'm looking for with the pat down is a weapon. I'm doing it for officer safety. That's the only reason I can touch you.
Okay. So this would be like on the side of a road.
Or in an abandoned area where somebody's standing next to a window. There's got to be some articulable reason that I want to come and talk to you.
Okay.
And it can't be prejudicial. It can't be biased.
Right.
It's got to be because
sus.
Right. Yeah.
Got it.
You're wearing red. You know, I've that. So I want to talk to you, but in order to protect myself, I'm going to pat you down and make sure you don't have any weapons on you.
Makes sense.
But if I feel a bag of marijuana, I can't take it out of your pocket.
Right. It's not a weapon.
It doesn't feel like a weapon. So that part's okay. What I can't do is say, hey, can you roll your sleeves up for me so I can take pictures of any tattoos that you have?
Right.
Right?
They did not ask me for consent.
No.
They did not explain to me their purpose, and there's no need to have proceeded the way they did. These are simple things that could have been done to say, listen, Ms. Gallagher, I'd like to swab your hands for gunshot residue. That will help us eliminate you from this case. Would you be willing to consent? Because the other option, of course, is to get a warrant for that, right? So what has to happen is you need to tell me that you'd like my consent. And then you need to tell me that I am allowed to say no.
Right.
That I have the right to say no.
You can stop the search at any time.
That's correct. So from a legal standpoint, even if I started this and then I moved into a space where I was no longer comfortable, I can say stop. And none of that happened here. One of the witnesses we've examined saying, but you're a lawyer. Yes.
You were a traumatized lawyer.
Yes. And I look at the videos and I see the woman who's there and I know that that's me, but she's so fractured at that moment.
Yeah, you can see it. You're traumatized. There's no doubt about it. And the bottom line is what's kind of shocking to me is law enforcement is supposed to protect human life. When they arrived on the scene, you ran out onto the balcony and fell into a ball and started crying. If I'm arriving as the responding officer, my job is to protect life. I would have stopped you just because.
Or just maybe check on me.
Or at least gone out and checked on you. But my concern is that you would have just run and jumped over a 19th floor balcony, right? I mean, bad things have happened in the past when you didn't secure things right away.
When someone's at such a heightened emotional state.
Yes.
And I think I had it together better. And then it was really a tough time. I was upset myself. Lolita, Tom's parrot, was at different points over this short window of time had been really hysterical and just acting out, screaming. I was worried about him and I was worried about me. And I was trying really hard to kind of keep it together. And then when the 911 operator told me that, I need to perform CPR and I'm saying he's dead. Ross is saying he's dead. And she was insistent and I felt threatened. I think she actually mentioned that I could face liability for not performing CPR. She did not want to hear if he was dead. I remember some sort of her challenging me that had I tested to see if he was still breathing. It's like, no, but he has no pulse. So if he has no pulse, to me, he's dead. In any event, so she had us really disrupt the crime scene. You have this 8-foot circular bed and I'm not going to touch the weapon. I don't want to do any of this. We were both really protesting, but I was also afraid. I was scared because I'm being told that if I don't, then that can be held against me. So I don't want that either. So that being commanded to perform assistance on someone who is already dead, that if I wasn't kind of hysterical before that, I have really messed up after that.
Well, if I look at the rest of the body camera footage, and I think I've told you this in the past, that if you were a criminal, you're the worst criminal in the world.
Well, thank you.
Because
you and Stephen both said
it's the thing is you were traumatized, and the unfortunate side of this is the traditional view of next of kin, where their policy indicates that a victim advocate should be assigned to the next of kin. Well, you were the only one that took care of him. You were the only one that visited him on the holidays. You were the only one that spent any time with him.
Right.
You were the only one that was caring for him. And in the end, the bottom line was you were his next of kin, and you were impacted by this more than anybody else. So
Not treated like that.
you were not treated like that. You were treated, to me, as a suspect.
I think a lot of that has to do with just there's a huge amount of prejudice and judgment here, bias, I guess. The prejudice just really was difficult. I think you're right. I mean, I don't know of that many nuclear families that exist today. For those who do, congratulations. That's great. But there are a lot of cases where friends become like your brother over the course of a lifetime, or you can have a friend who takes on a father or a mother role in your life. And who are we to require people to stick to constructs that really don't exist in at least what half of all families are fractured at this point. There's a lot of blended families. So I think that one of the things that really has upset me here is that Tom made known, and we're not just talking about his most recent will. The state has all of the stuff from Tom's computer and his email. And, the prior iteration of his last will and testament was emailed from his prior attorney. So they know, even then in 2014, Tom trusted me to be his trustee. He trusted me to be his executor. After that, twice he trusted me to be the trustee over his parrot. And I know, you've met Lolita plenty, and, a parrot lives forever. And so I think the bond there was pretty strong because they were together for over 30 years. So to ignore what I was saying, but also to ignore what you have access to and you are aware, because the paperwork was just all over the apartment. There are photos of it in the crime scene photos of the last will, of his medical power of attorney. To ignore what the decedent is saying he wants, to me, that takes some chutzpah. I don't understand it.
I think as I look at this scene, if I had some comments to make about, and I won't get too deeply into the processing of the evidence at the scene, what should have been done, what shouldn't have been done, but what I will make is generalities. And in those generalities, what I'll say is you had way too many people
Yes.
walking around, touching things, moving things.
And part of that's because they chose to use a crime scene as a training ground.
Correct.
So you have, a trainee trying to render safe the weapon.
Right.
And the result of that is that blood is smeared everywhere. Now a second person is having to do that.
And fragile evidence is destroyed.
And I'm just stuck with whatever it is that they choose to collect, whatever it is that they choose to preserve, and with the level of care that they choose to employ, that's what I get. Yeah. Because even when you try to advocate for yourself, I wanted to get all the 911 calls, not just the one I made that morning, but the 2 calls I had made in the days before. I wanted those calls because I know what I discussed with the 911 operator and the responders. I wanted all that information because I knew that was helpful. And I was not able to get that because once there was an active investigation, no one from the public, including the person who had made the phone call, has a right to that information under Florida law. I don't know if that's a norm, but I found that pretty.
I just know from this perspective, if I'm working this case and you tell me that you called 911 twice the day before.
Or the days before.
To get somebody out there. And from what I've seen in the paperwork, they got to see Tom. They got to see how he was. They got to see his abilities. Right. They got to talk to him. They got to find out what the issues were. And they also talked about suicidal ideations.
Right.
Those
Correct.
things are all important. All of that is important.
That's assuming that when we were talking about the fork in the road that exists in an equivocal death scene, that you have to be considering both
absolutely
candidates. And if only one is important to you, you kind of show that this other avenue is not at all important to you, because they didn't think it was important. They didn't bother. They did not preserve those calls.
Yeah. And they did not collect all the suicidal ideation notes. If I look at that all comes back to one issue that is a big issue. And it's in most of the training that's being done now for law enforcement and detectives and CSIs, and that's confirmation bias.
Oh, yeah. That was made so apparent over the last few weeks of deposition for this phase of discovery here, so we're close to trial. I actually thought trial was going to be starting in a week's time, but I'm being slow walked to the gates of justice here. And in measure, some measure, I really do understand. I seriously do understand that. And I know you know that. If someone is in jail awaiting trial and they have conflict of dates with mine, absolutely, they should go first. I think, though, that there should be a better system and process that you're not still hearing cases from people who've been locked up since 2021 or 2018. To me, that's a systemic problem, and we can blame COVID for some of that, but some of it is also just the way that this system moves. It's molasses like. So I do appreciate that problem. But in this last couple of months, maybe last 3 months or so, with discovery moving as it has, the confirmation bias is probably theme number 2 for me. Theme number 1 for me is I'm not responsible. That's him. That's her.
Oh.
The number of people who are just pointing the finger at that, she should have done that. He could have done that. She's responsible. He's responsible.
So
there's no one in charge.
That's the problem, If I had one thing to lay out there, it would be leadership. In this case, there was no law enforcement leadership to say, you need to do this.
But in this case, we've got no warrant. So the Fourth Amendment has been shoved aside. It's not being respected. And that's not just in terms of the scene. I mean, we have plenty of evidence as to what's happening with other items. The digital items each, would require their own warrants, most likely, from a Fourth Amendment perspective.
But they never documented what they looked at, nor did they ever share, nor did they make a decision to collect, nor did they make a decision to do anything with it.
Right.
How many reports that the FLPD policies call for?
Written statements.
Every officer that goes to that scene does a supplemental report. Right? How many supplemental reports do we have from the scene?
So we have the initial investigative report, which was written by the junior officer who was in training. And so that's a co-authored thing with the training officer, also on that. There is a very brief report from one of the patrol officers who checked in and basically left. And I think it's about a paragraph. There's the first responding officer gave his notes to the junior officer who wrote the incident report with her training officer's assistance or oversight. So he actually didn't write a report. He handed off his notes. And so that's, so far we've got 2 reports. Then there's the one from the lead detective. When we asked questions of the other detective who was at the scene, he didn't take any notes while there that I saw. And he didn't take any notes. Yeah. And created no report. He did nothing like that because he was not the lead detective. So it's an interesting situation here to see. When you read the written policies, it all looks pretty good. Everyone's going to write a report. You're going to interview any possible suspect, any witness, any victim. You're going to interview them all. And actually, it's supposed to be the detectives who are interviewing those people. But in terms of the full approach that was taken, I think that fundamentally the constitutional rights, had those been respected. I mean, you have a sergeant who's on scene for quite a while, and he knows full well that there needs to be a search warrant for that residence. The landmark case is Riley v. California. It's been years since that decision was made, and that's related to phones. And what the U.S. Supreme Court says in the case of Riley is there's so much data there. When the founding fathers were talking about, when the founding fathers were discussing or trying to figure out a way to protect people from unreasonable search and seizure, they're thinking that you're going to have soldiers show up at your door and they're going to go through and they're going to find your candle collection and the dozen or so books that you have or whatever. Is that the property is so limited and there is nothing digital. In the case of the results from the Google search warrant, 80,000 unique artifacts from my Google accounts, over 600 documents. That's mind-boggling. If you were to bring Madison and have him sit down here and say, so how would you handle that? Get Thomas Jefferson over here, have him weigh in. So they wouldn't know what to think about any of that. No. And they'd say, wow, you really have to protect people. And so we do have really strict requirements. You have to get a warrant.
Yeah, but not only date parameters, but parameters on what you're looking for.
Right, because it's so voluminous.
You can't. There has to be filters. Right?
Agreed.
And those filters have to be related to what they're looking for. And that's got to be specified in the probable cause.
I agree entirely. And that wasn't done here. They did apply for a warrant for my cell phone here, and I agree with you. It's way overbroad. It's supported by a flimsy warrant affidavit, in my opinion. But they didn't wait until they had that authorization to search my phone. So when you hear about cases being thrown out on technicalities, to me, I used to be aggravated by that as a law student. I remember thinking like, oh my gosh, that's crazy. That bad guy is literally going to get away with it. But there are protections and safeguards. And if they're ignored in terms of the bad guy, then they get to be ignored in terms of everybody. And that's where you get into a really ugly space. So, the bottom line is just do it. Just do it correctly. If you do it correctly, you're not going to risk losing someone who's actually guilty and actually.
Right. Now, that's the other side of the coin. In this case, it makes it difficult to defend yourself because
Yes.
the right things were not done.
Right. The evidence that could have been helpful was not collected.
Right. Because it wasn't done to accomplish those two pillars and objectives. But it also cuts the other way that, if you don't do it right, you're losing the ability to catch someone that actually did something.
I can't wait to get up and get out of here. The system tapped into my deepest fears.